Your Honor, there is a section of a police report that alludes to an incident many months earlier, several months earlier, in which Brianna Moore fully cooperated with a police investigation about a man who had a handgun on campus, apparently. She provided a lot of helpful information. She cooperated. It has nothing to do with this case. I guess that was put in a police report because they didn't know who the father of the child was and what the circumstances were at the time that the report was generated. But it's clear at this point that that incident has nothing to do with this case. It would be prejudicial to bring it up, and we seek to exclude it. And by prejudicial, I mean also it would not be relevant, and it would be prejudicial.
What's the date of this event?
April of 24.
Because this is, what, January 24, I think, the gun?
And, Your Honor, what happened is during the course of the investigation, of course, law enforcement was pulling all records related to Ms. Moore's time at the University of Tampa. There was no indication that we were going to introduce it. We just had to provide it in discovery.
Okay.
Understood.
So I'm going to grant that because it doesn't seem like you guys are using it at all.
Correct.
And then, so then the last one is defendant's renewed motion to modify bond release conditions. I read the motion as to her moving back to Mississippi.
That's not the last one. There should be a motion, a Daubert motion as well. But we can address that after we do the bond motion.
I do not have a Daubert motion.
Should be two Daubert motions. We filed a notice of hearing with them on there. Those were the hearings that were today's original hearings. Everything else was added on afterwards.
Yeah, I'd like to be prepared for my hearings and read in advance, and I'm sorry I haven't read those. I didn't even know those were on the docket today. Can we reschedule those? I mean,
We can reschedule them. That would be the third time that these motions have been rescheduled. Defense was supposed to produce the witnesses for both the motions because they're two defense physicians that are the basis for the Daubert hearings. So I would ask that if we're rescheduling this, the court order them to have their witnesses present because I don't see them here.
Your Honor, it's not on the docket, so we checked today and confirm it's not on the docket. So we didn't bring the witnesses, of course, and
That's
didn't.
fine.
So
I will make sure that on the next one, whatever witnesses they're requesting, I apologize. I really read my motions beforehand.
Right.
I like to be prepared for the hearings before I come in. I did not know that you had a Daubert motion.
And I know that this court's not aware of it. Defense counsel was present when these hearings were set in front of Judge Palermo. Those two motions were the basis for today's motion hearing. Every other motion was added on afterward to the already scheduled hearing of today. I know that this court wasn't aware of any of that because that was in front of the prior court, but defense counsel was aware. So I'm asking that when we reschedule these, that the defense counsel is ordered to produce those witnesses because this will be the third time that they've been reset because the witnesses were not produced the first two times.
That's my fault. I apologize because, like I said, I want to read the stuff and have it. So at the next hearing, contact my J, should give you a hearing date, and make sure your witnesses are available at that time.
we already did address one part of this motion with one of the witnesses, and the court denied it without the witness even being here. So we didn't actually bring the witnesses when there was a previous such motion for Dr. Nicole Graham. So it could, we don't know the scheduling yet, so it could be onerous to have the witnesses here. I think both of them are local. We're talking about Lilia Passman and Dr. Knudsen Gonzalez. Is that correct?
Those are the two motions, and
So-
state's not stipulating to deposition transcripts for either of those witnesses.
Okay.
And just for the record, Your Honor, the deposition transcripts and were previously provided to the court as documents to consider all of the depositions relating to our experts, and the motions that the state has filed issues for are on the record. They're filed with the court and were considered by the court in the previous hearing, so we would object to that not being allowed. If our witnesses are not present, that doesn't mean that the state's motion is just granted per se. There is actual evidence of sworn testimony that's recorded by a court reporter that can be used by the court's consideration.
Only if the parties stipulate.
I think they're right about that. I think only if they probably stipulate to those and things like that. I don't think they are.
Like if the state wants to provide us case law and memo,
You want to do that down to me like Zoom? That's fine with me. And we don't have to go to the expense of driving them in there. I'm sure it's expensive. I don't probably do it by Zoom. Okay with y'all?
That seems like a good compromise, Your Honor.
What physicians are you talking about?
It's Dr. Knudsen Gonzalez and Ms. Passman.
Okay, so make sure they can appear via Zoom. We'll do them one at a time so I can hear what they have to say. So any other issues that we need to address?
None from the state, just defense's bond motion.
Yeah. Anything from the defense other than the bond motion?
No.
I've read it. She's bonded out, and you want her to move back to Quitman, Mississippi. Anything you want to add that you didn't argue before?
Yes, Your Honor. So some additional points that I wanted to make sure that we didn't go over in court yesterday. Brianna Moore is indigent. Just because her family has resources and might have the ability to do so does not mean that she has the ability to do so. She's 21 years old. She's a legal adult. Right now she has 48 cents to her name of what was refunded to her from the jail. The entire family is in Mississippi. That's where she was born, raised. Family has been there for generations. She has 5 potential different houses that she could live at there. She currently has no ties to Hillsborough County. And given all of the publicity that has been happening in this case, I don't know that she'd be able to actually be a productive member of society if she wanted to get a part-time job or do other things as well to not be harassed if she is out in public in Hillsborough County. She has her family members. Her family is here today. They've come to every single court date. Back in February, her dad came down for court in November, for the hearing date in November. Mom, dad, and grandma all showed up to court. So the state's supposition or propositions yesterday that she's a flight risk and not going to return to court is incorrect. Her family has been here when they don't even have to be here. And they make the drive or the flight every time from Mississippi to come and support their daughter. Ms. Moore was released with the ankle monitor. It's a hard plastic one. It's not one that you could cut off, so she is being monitored. They can't set the parameters so that she does not leave the state of Mississippi or the town or county that she's in unless she's traveling for court. Additionally, the state's argument yesterday that she's a flight risk, there has to be a substantial factual basis to show that she is an actual flight risk. She does not have a passport. Her driver's license is currently expired. It expired while she was sitting in jail, so she does not have a way to get around. She has no money to go anywhere. So being able to be with her family, supported by them, the community over there is loving and supporting of her. She would be able to get a job, spend time with her family in the meantime, and of course would appear in person as required for all the court hearings moving forward.
Okay.
There's been no change in circumstances, and there's been no evidence presented to this court that there's a change in circumstances. Without a change in circumstances, this court cannot consider a different bond than that imposed by Judge Sabella at the pretrial detention hearing when he heard from witnesses, he took testimony, and he was presented with evidence to support the charges that the state has brought.
If Your Honor would like to hear from the family as well.
I'll tell you what my concern is.
Mm-hmm.
I mean, she moved to Quitman. I get the financial end of it. I do. I understand what you're talking about. I mean, she doesn't have any ties here. Her family's in Mississippi. I mean, I completely understand it. It is a financial burden. I'm not saying it's not. My concern is, let's assume she goes to Quitman and she runs. And I'm not saying she's going to run, but let's just assume for a second she does, okay? I don't know how big Quitman is. I don't know if they have a police force. I'm not saying I want to bash Quitman, Mississippi. But I don't, let's assume she runs. And I'm not saying she's going to. And Ms. Hodges calls or whoever to have her picked up. I mean, I don't know if there's a police force there at all. I have no idea if there's any way to enforce that. I mean, she could cut her monitor and fly off, and I'm not saying she's going to do that, but I mean, that's the concern of, the financial one that you're talking about is her family's there. I mean, I get that. I completely understand that, but, I mean,
So
that's what the kind of thought process. You got something to address, I'm all ears.
yeah, To address the court's concern, I know yesterday it was brought up that she was arrested in Mississippi and that she wasn't here. Obviously, after this incident, she disenrolled from the University of Tampa, moved back home to Quitman, Mississippi. She had a part-time job and was enrolled in university over there in dependency of before the warrant was filed, because she was told that she was free to leave. Before leaving the state of Florida, she gave law enforcement here all of the addresses of everyone's home and where she would be, which is where they found her when the warrant was issued for her arrest. There is a law enforcement presence there. They would be able to pick her up or check on her. I don't know how much control Florida has over Mississippi, but in addition, with the ankle monitor, and I'm happy to have the court see the monitor, it is a hard plastic ring.
Okay. I mean, but you could, let's be real, you could cut, I know there was a couple of years back where someone cut one, you could cut it if you needed to.
Well,
I'm not suggesting she is. I'm not saying that she is. I don't want you to, but I mean, my concern is she's in a different jurisdiction.
Yeah, well, it's also, bond is paid. There is a bonds agent. There is a GPS monitoring company. The bonds agent, along with the family, would make sure that she returns to court. If not, that's $26,000 that the bonds agent is losing out on. That GPS monitor is one of the highest technology. It's better than what's provided locally from the jail when people are released. It is really not able to be cut off. It's 24-hour monitoring, and
Judge,
you
there's
can
no
bet
evidence
that
of any of this. There's no evidence of any
that
of
the
this.
bonds agent would turn into Dog the Bounty Hunter if she were to run, but she's not going to run. She did not run after being investigated by police. She could have gone anywhere in the world, and where did they find her? At home. So the actual reality, is it a possibility? Yes, anything's a possibility. But the reality of if she's going to run, no, she's not. We've been in contact the entire time with her family, with her. Mr. Dixon and I don't have any concerns that she is going to run, with her family being able to support her and bring her back when they have been back to court, when they haven't had to be, along with the GPS monitoring and the bonds agent that would also assure her presence in court. That is specifically what bond conditions are required to secure a person's return to court, not to limit otherwise their life.
No, I understand. Okay. Mr. Dixon, you want anything?
Yes, I just wanted the court to actually see the monitor. It's not a normal one that this would take some industrial strength thing to break. I'm serious. I just saw it and I can't believe it. This is a serious object. It's like a ball and chain. So if I could have her approach and just stand right there and show, this is not the little thin monitor. This is several inches thick.
Okay.
Also, I wanted to point out, she was fully cooperative with this investigation. From the first time she talked to law enforcement, gave multiple statements to law enforcement, answered every question. The remains of her daughter were given to her at the end of the investigation. She took them home in an urn, the cremains. They're in her home. She graduated from the University of Tampa from that year. So I'm misstating that. She finished the semester, passing her courses, transferred to another university. She was in the semester there in Mississippi, and out of the blue, this arrest happened. I asked Detective Campbell, why didn't you just tell her to come back to Tampa? But she's been fully cooperative and answered every question, and that's reflected in the police reports. It's undisputed. She's been obviously at every hearing, and so has her family, fully invested in this case. We've been doing thorough discovery. We're prepared for trial. So there would be no reason for her to run away, and no pattern to suggest she would. Obviously, no prior record. She was here on a scholarship. Now she transferred to another university, and she was in her sophomore year when this case was initiated 5 months after the incident. So she's fully cooperative.
Okay. At this point, I'm just going to deny your motion. So I think that concludes all the stuff except the Dahlberg stuff. Contact my judicial assistant, and she will get you the court dates on the other Dahlberg motions. Are there any other motions that we need to address? Anything else? Other than 2 Dahlberg ones? Do you have anything else?
No, not from the defense at this time.
Okay. All right.
Judge, things that do need to be addressed regarding the defendant's bond status. Her address is not updated with the clerk, and her bondsman information is not updated with the clerk. Given that she is out on the on a monitor, the court and the state are entitled to monitoring reports because the bondsman appears not to be local from the documents that are filed with the clerk and with the court
So
system.
you want her new address?
We need addresses so that it's reflected in the record because it's not reflected on the jail screen documents so that the court knows. And if there is an issue with the failure to appear, law enforcement knows the addresses that she has provided.
Do you have an address now? Don't put it on the record.
No, the family's staying at an Airbnb right now through the weekend, and while we have looked at options of where she could stay here locally, nothing's been booked yet because obviously it's a cost to the family.
Well, that's a problem because she shouldn't have been able to bond out without a permanent.
She has an address
I'm
that
sorry,
she's
I was
staying
speaking.
at currently.
Shouldn't have been able to bond out without a permanent address, and so that address has to be updated with the clerk.
Will the permanent address be in Quitman?
No, it has to be the address where the bondsman's defined her here. So she needs to have a permanent address here. She needs to have that on file with the clerk. Her address needs to be updated with the jail, and then her bondsman has to have that. Because of all that, the state's entitled to that address. The court is as well.
I completely understand that, but I can't make her do the impossible. She just got to jail last night.
I know.
So I've got to give her at least some time to find a place. So how much time is reasonable? I
Well,
can't
what-
ask her for the impossible to give an address that doesn't exist.
Sure, I agree with the court. The problem is that she shouldn't have been able to bond out and have a bondsman post it without that permanent address. So that's already in place. So
Okay, well, I
I'll agree
understand
with
that, but we're still in the position of how much time is reasonable.
Then I think let's go with 7 days is what the state would be asking for her to have a permanent address and for that to be provided to the clerk, to the jail, to the court, and to the state.
7 business days. Okay. All right.
And then the monitoring reports would need to be provided on a weekly basis, or at least the state's asking for monitoring reports to be provided to the court and to the state on a weekly basis by the bondsman.
If
So the
this,
GPS is what you're
Yes.
doing? That's fine.
if the state could provide a proposed order with all of that so we know exactly who, what email addresses and everything
That's fine.
that would be sent to.
Okay.
All right, thank you.
All right, thank you. That concludes these proceedings. Thank you very much. Point of adjourned.